So I'm going to briefly introduce our first keynote speaker, Professor Mike Schmitt, who is very. So I'm going to introduce our first keynote speaker for the conference, the one who's doing the morning session, Professor Mike Schmitt is well known in this country, is well known in many other countries.
Russia, China, yeah. That's right.
So Mike has three university affiliations. This is already quite remarkable. He is the professor of public international law at University of Exeter. He's the Charles H. Stockton Professor of International Law at the United States Naval War College. He's the Francis Lieber Distinguished Scholar at the Lieber Institute of the United States Military Academy at West Point. On top of his three academic appointments, he is also a senior fellow with NATO Cooperative Cyber Defense Center of Excellence in Tallinn. He is also, I should say, a research associate with our center at Hebrew University. And he has many other distinguished titles, but we only have an hour, so I'm not going to go over them. All of them. I would mention that he's the general editor of the International Law Studies, which is the most it's the oldest international law publication.
It's the best international law publication and the oldest in the United States.
It's the best and the oldest in the United States and beyond. Well, the best beyond. And of course, Mike is very well known for his work in the field of IHL. He's been involved in some of the most important projects and has authored some of the most important publications in the field. I will just mention that on top of his key role in putting together the Tallinn Manual, for which he was the general editor for both Tallinn 1 and also for Tallinn 2, he was also involved in other very important rule-making projects, including the direct participation in hostilities project that the ICRC has put together, and before that, the Manual on International Law Applicable to Air and Missile Warfare. He is now involved in the project relating to the applicability, the international law applicable to military uses of outer space. And I think he also wrote the manual on non-international armed conflict.
With Yoram Dinstein.
With Yoram and
yeah,
Charles Garraway, which is
yeah.
not on your on your Wikipedia page, so you have to correct that.
Okay.
Mike has been a very good friend for many years, and we are very delighted to have him. He was also here yesterday when we had a whole symposium on the Tallinn Manual at Hebrew, and we are very pleased to kick off this conference with Mike. We could think of no one better than Mike. So thank you, Mike, for being here, and thank you for your friendship and support.
Oh, thank you, Yuval. We've known each other for a lot of years, so I'm really appreciative. I'm also appreciative, I have to say, I'm not usually invited to human rights conferences. That may come as a surprise to some of you. Indeed, this is only my second human rights conference in nearly 7 decades of life. I'm in my 7th decade of life, and I've been to 2, and I organized one of them. So this is a very special moment for me. I'm not going to talk about human rights in particular. I'm going to talk about a dynamic that I'm seeing in international law relevant to cyberspace right now, but it has direct relevance to human rights. Because when we were doing the Tallinn Manual, and Deb was one of the experts, without a scintilla of doubt, the hardest subject we dealt with was human rights. And in fact, when I look at the Tallinn Manual, and Deb will remember, we went around and around and around. There was a first draft, and we rejected it, and a second, and we rejected it. We sent it out to very eminent peer reviewers in the field, and they had oodles of comments. And at the end of the day, I believe that the human rights chapter in the Tallinn Manual is the most unsatisfactory chapter. And the reason it's the most unsatisfactory chapter is not because we didn't do our homework, and it's not because human rights lawyers can't make up their mind as to what the law is, although there's a sense of that. It's just because the law, the international human rights law, when applied in the cyber regime, is really, really tough to nail down. there are often multiple reasonable interpretations because of the very thing that Amit said, which is how do you find the appropriate balance between security and the rights of individuals. So as I talk about gray areas, I'll talk about other areas because those are my specialties, but you should think human rights because of all the subjects Deb and I and the other experts dealt with, I think, Deb, it's fair to say this was the grayest of all the gray areas. All right, in any presentation, it's always good to start at the beginning. Most of us think of the beginning as Estonia in 2007. In this audience, I don't need to remind you what happened in Estonia when there were massive cyber attacks. But in fact, we began to look at cyber and international law long before that. In fact, the father is in the back right corner, your left, Walter Gary Sharp. I think, Gary, you wrote probably the first book on international cyber law. I think it was published by Aegis Corporation, and then Gary was participated in the very first major conference, which was held at the Naval War College, and contributed to the book. So if you want to meet a father of this field, shake Gary's hand at some point. But in the 90s, we all began to look at cyber and international law. And books started coming out. So Gary's book, he wrote a number of articles. We did a book at the Naval War College. I wrote a few articles. But then 9/11 really took the wind out of the sails of international law and cyber because folks like us, we were concerned about something else, black sites, torture detention, kinetic operations in the battle space, and so forth. So it wasn't until 2007 that we started thinking about it again, and this was really a watershed moment. I remember that. Some of you aren't old enough to remember it unfolding, but I remember it very vividly, because the Estonians were making noise about coming forward to NATO and looking to Article 5 of the North Atlantic Treaty for the NATO countries to come to the defense of Estonia against Russia. And let me tell you what, that got our attention in a big way because we were rather tied up, the NATO countries were rather tied up elsewhere, in Afghanistan, Iraq, and so forth. And we thought, holy cow, because of cyber, we're going to go to war with the Russians. Well, eventually things calmed down, as they usually do. But the lawyers had been caught confused by all of the events that they were witnessing. They didn't really understand what they were witnessing. So when their clients and MFAs and MODs came forward and said, what are we seeing here? Are we seeing a use of force in violation of Article 2.4 of the Charter? Are we seeing intervention? Are the actions of these non-state actors, are they attributable to Russia? Can they be deemed to be Russia? What can we do? Are countermeasures available? Et cetera, et cetera, et cetera. Some of you will remember this. We didn't have any of the answers because everyone had quit thinking about cyber. And then in very rapid succession, there was the very next year a war, an international armed conflict between Russia and Georgia. And again, cyber figured prominently in this armed conflict. And so this caused those of us who worked in public international law to begin to focus on cyber law, to figure out what is the law. And the project which I was affiliated with, it wasn't the only one, was something called the Tallinn Manual. NATO had, in the aftermath of the events that had been seen, NATO set up a cyber center to look at cyber law, cyber policy, cyber tech issues, and they wanted to take a look at the law, so they contacted me and a bunch of other experts, and we began the work on the Tallinn Manual. Now, initially, we looked only at two subjects. We looked at the jus ad bellum, the law governing the use of force, the law of self-defense, Article 2.4 of the UN Charter, Article 51 of the UN Charter. That was our focus because those were the questions that had been raised by the Estonia case. We also looked at international humanitarian law because those were the issues that had been raised by the Georgia case. We did not look at peacetime law, even though peacetime hostile cyber operations had become rather frequent by that time. But, you know, if you're going to eat an elephant, do it one bite at a time. Because this had been the current issue, we dealt with that. And we labored for 3 years, and we produced a book. It's the book on your left, the blue book. Tallinn 1, it's now called. We didn't think there would ever be a Tallinn 2, frankly, so we called it the Tallinn Manual. This manual dealt with these two subjects. What we thought we would do with this manual was simply provide, and I mentioned this yesterday in the event, we were just going to give some help to those who were dealing with these situations. You know, I'd been an attorney for many years, for decades, working for the government, for the American government, and You know, when something bad happens, you kind of sort of want to have something to look at. You don't want to look at the incident when your boss comes in and says, holy cow, we're taking cyber hits and these are the consequences. You don't want to go, okay, let me start from the very beginning. So that's all that was. But that got a lot of attention. And so the NATO Cyber Center came to us and said, you want to do another project? That was good. We'd like to do that again. And we said, let's just keep going, because the legal advisors, the Amits of the world, the legal advisors, Tallinn 1 was about their catastrophic event. It was about their nightmare event. They're at war, and cyber operations are proceeding. But on a day-to-day basis, that's not what he deals with, and it's not what any legal advisor in this room deals with. They deal with the frequent events that happen during peacetime. They deal with OPM hacks, DNC hacks, and so forth. So in Tallinn 2, which we started in 2013, and finished this year, published this year. And again, Deb was one of the members of the IGE, International Group of Experts. We looked at the peacetime law. So in the academic, non-governmental community, we've made a lot of progress. I mean, we found 154 rules, 600 pages of legal blah, blah. Okay, that's a lot. It's a big book, okay? So we were of the view, these experts, and it wasn't just the experts. There were two different group of experts. 19 here, and 20 here and 19 there, plus we had 50 experts spread around the world. Some are in this room doing peer review, plus we went to states and met with states 3 separate times. Some of the representatives, again, of states are in this very room. They provided us input, both verbal input on early drafts of the manual, as well as, and I'm not making this number up, thousands of comments on the drafts. We think this word should be that word, and so forth. So there was a lot of input, and there was relative consensus, I think, when the book came out in February. There was relative consensus that there was a very rich, thick web of international law that governed cyber operations. I mean, there was a lot of it, and everyone pretty much agreed at that point. But in my mind, I was a government attorney, so I was really concerned about what states were thinking about our work. And I have to tell you, the first Tallinn manual, there were only 2 states that really raised eyebrows. They were Russia and China. Many states bought many copies and gave it to their legal advisors when they were assessing reviews. So with regard to the first Tallinn manual, there was almost no pushback from states. And even the Russians and Chinese, even though the governments kind of raised eyebrows about the manual, it was quickly translated into Chinese legally. And then for those of you who know Russia well, it was quickly translated into Russian illegally and placed on the internet. So it was being used by everyone. Ditto with regard to Tallinn 2, they looked at this as an academic work, which was all we had said it was, but governments really embraced it. These are a couple of comments that you'll find. Ilves, who's the president of Estonia, Estonia is not a superpower, but it is kind of sort of a superpower in cyber matters, certainly cyber policy. Ilves is probably the best known head of state that deals with cyber matters. And then the Dutch, I mean, I see our Dutch colleague from yesterday has already gone home. Paul went home. But the Dutch, I mean, they were almost like stalkers with us. I mean, what can we do to help? You know, we believe in this international law. We want to push it. And so the Ministry of Foreign Affairs, this is the comment made by their minister, the Minister of Foreign Affairs, the Ministry of Foreign Affairs was extraordinarily supportive. So at this moment in time, I think everyone is fat, dumb, and happy. Okay, we did this work. Took a lot of time. I didn't have gray hair when it started. I was taller, okay? But now we got a book, and it seems like everyone likes this book, and it's going to serve the purpose we had originally intended, which was legal advisors were going to use this to help wade through the issues that they were dealing with. Now, I will say with regard to this book, we did do one thing that was different. In this book, we assiduously tried to capture all uncertainty out there. So sometimes the book is unambiguous as to what the law is, what the experts believe the law is, and sometimes the book is intentionally ambiguous. We don't know what the law is here, or there are multiple views. At any rate, states, and I'm a classic international lawyer, states and only states make law, so what were states doing about this time? Well, they had formed in 2004 the very first group of governmental experts. There would eventually be 5 groups of governmental experts formed by the United Nations, a grouping of states which would assess many things, but one of the things that these GGs were going to assess were the norms that applied in international law. And so at the same time we were operating in the non-state actor space, states were through this process looking at exactly the very same issue. Now, they didn't produce as much of us because they weren't as agile. We were academics, we left our politics at home in most cases, whereas politics intruded in their deliberations, but they made a fair amount of progress. I mean, they are to be commended. There were 2 major reports, one in 2013 and one in 2015. This is the 2013 report. Some of you will remember in the very beginning the issue was, does international law even apply in cyberspace? Or is this some kind of new regime? Well, to a serious international lawyer, that's a silly question. But this was a question that was being asked, and by 2013, the states that were participating in this progress were comfortable saying international law does apply to cyberspace, basically telling the academics what they already knew. Said that state sovereignty, I'm going to come back, applies. They said that human rights applied. Be careful, respect for human rights applied, meaning that the state has to respect human rights in its operations. They could not use proxies, and this is an issue for the lawyers' state responsibility, and then ensure their territories are not used to the detriment of other states. This is, of course, the principle of due diligence. So this is pretty good progress, and then 2 years later they build upon this initial progress and issue a 2015 report where they go even further. Here we see states, remember these are states coming together in consensus reports, and by the way, the states included all 5 permanent members of the Security Council. So this is an agreement between the United Kingdom, France, the United States, Russia, and China, as well as the other states like Estonia that participated. Jurisdiction, so they moved from sovereignty and now they embrace jurisdiction. Prescriptive, enforcement jurisdiction, adjudicatory jurisdiction over cyber infrastructure on its territory. Sovereignty, reiterate the applicability of notions of sovereignty, but go further and talk about now sovereign equality between states, which is obviously a very important principle. Talk about peaceful settlement of disputes, a legal obligation to settle those disputes which are likely to cause a breach of the peace peacefully, to attempt to peacefully settle it first. And then now they've introduced the notion of the prohibition of intervention. So they've gone farther. One state may not intervene in the internal or external affairs of another state. They noted the inherent right to take measures in accordance with the Charter. This is UN speak for self-defense, because an inherent measure or an inherent right to take measures is the inherent right of self-defense recognized in Article 51 of the UN Charter. And here we say they noted the principles of humanity, necessity, proportionality, and distinction. That is, of course, international humanitarian law. So the P5 and the other states are recognized that international humanitarian law applies to operations, cyber operations conducted during an armed conflict. By the way, I skipped over human rights, which is a bad miss in a conference on human rights. Remember in 2013 it was respect. Now it's respect and protect. In other words, this was this group of nations saying states not only have an obligation to, in the dealing with individuals over whom they exercise effective control, to comply with their obligations, but also to take measures to ensure that others comply with their obligations vis-a-vis those individuals too. And then again, the principle of attribution comes up in proxies and due diligence with regard to police and territory. So all is good. Listen, we got this manual. Everyone kind of thinks the manual's cool. We have these GGE reports. They're all going along. Kumbaya. International law is embraced by everyone except for the village idiots. But that didn't last very long. What happened? Hey, Danny, hi. What happened then is that there started to be backpedaling. You see, in 2016, another GGE was formed, and in 2017, that GG was unable to issue a consensus report, despite the fact that the previous 2 GGs had done so and had been very robust in international law. And they this GGE was unable to issue a report on three prime issues. The first is an issue that, in fairness, is an issue that is unsettled in international law, and that's the right to respond to an internationally wrongful act. China, Russia, Cuba, a number of other states, we're uncomfortable with the notion of countermeasures. This is the right to respond to an internationally wrongful act means countermeasures, as set forth in the Articles of State Responsibility. Okay, that one I get. That one I get, because countermeasures were controversial. Deb, they were controversial for us. Okay. But the other two, holy cow. The second one is the right to self-defense. They were unwilling to put the word self-defense in. You got to be kidding me, because in 2015, in 2015, the right to take measures consistent with law and recognized in the Charter, that can only be self-defense. It's the only thing it could have been. So now they're uncomfortable with the right of self-defense, and they refuse to put the term international humanitarian law into the report as well. They have a cat fight over this, which is, again, very confusing. Remember, because just 2 years earlier, they were talking about humanity and necessity and so forth. So what we're seeing here is backpedaling from the high point of international law in this body of law, and now that is bled over into individual states, my state most notably, because those of us who were at the other Hebrew University campus yesterday know that there's an ongoing debate, a very important debate over sovereignty in cyberspace. Gary Korn, who's a very much a close friend of mine. By the way, you will be amused to know, Danny, and that Gary and I were even arguing about this morning. We were exchanging emails as we were brushing our teeth. No, you're wrong on this. So this is a fervent debate. Gary is the legal advisor to the United States Cyber Command, which wields offensive capabilities in cyberspace for the Americans. He publishes an article along with a very senior attorney at the DOD, the Deputy General Counsel, before Trump came in and fired everyone. I should say, since I'm being recorded. So I work for the United States Naval War College. In part, my views do not necessarily represent the views of the United States, and let me assure you, they don't represent the views of the United States, so please don't assume that they do. At any rate, Gary and company, they start making this pitch that there's no rule of sovereignty. Rule of sovereignty. There's principle from which other principles like intervention come, but there's no rule. So a cyber operation into another state's territory will not be unlawful unless it breaks one of the big rules, like the prohibition on the use of force or non-intervention. Well, this is an incredibly important argument, because the rule that is most likely to be violated by a hostile cyber operation into another country just happens to be sovereignty. So it's a huge debate. It shows that states are a little uneasy with the constraints that international law is putting on them. Those of us who believe in the concept of sovereignty say the argument should be about where is the line? When does an operation violate sovereignty? Not can an operation violate sovereignty. So we see states starting to be nervous now. And by the way, this virus plague appears to be spreading. We hear noise from other countries like the United Kingdom and elsewhere when we travel around. I would emphasize that this is not the position of the United States. The United States doesn't have a position on the issue right now. We're trying to figure out what the position is, and I think that's true for other countries. But you see this sort of pushback against the notion of the applicability of classic principles of international law applying over and over. And for those of us who were here yesterday, that's what we saw, right? We saw this debate starting to emerge with the folks in the room. Now, that's because states, some states, not all states, some states or some entities within a state like ambiguity. They like it. We were talking, one of us was talking on the break this morning about this. Why? Why is ambiguity good for a state? Well, if you have clear rules of international law, it limits what you can do, right? International law says you can't do this. So take sovereignty. If sovereignty is a rule of international law, the client comes forward and asks you, can I conduct this operation? The answer is either yes or no, you cannot, because it violates sovereignty. But if sovereignty is not a rule, you don't ever get there. You don't ever get there. You have to look for some other rule of international law, and you're unlikely to find one. If you're in the battle space with regard to international humanitarian law, the question becomes, can I conduct cyber operations against civilian cyber infrastructure in the battle space? The answer is, my answer is, sometimes you can, sometimes you can't. But if IHL doesn't apply, then there's no rule that says you cannot. Okay, so it gives you, it takes away those things that would stop those operations you may want to engage in. Moreover, if international law is unclear, then it takes away the ability of other states to come together to condemn you for engaging in operations that violate international law. If we don't know what the DNC hacks were, as a matter of law, it's hard for us to get together and condemn the Russians for having conducted them. Okay, and the Russians did conduct them. I heard your comment this morning. In my country, there's at least one person that believes they did not, but everyone else believes they did it. Okay? Moreover, international law provides clear lines, clear mechanisms for engaging in very robust responses. International law, people think of international law as prohibition. International law allows you to engage in certain operations consistent with the rules of countermeasures, and operations consistent with the law of self-defense. And if the law is uncertain and you engage in a cyber operation against another country and the law of countermeasures is uncertain and the law of self-defense is uncertain, they're going to wonder, can I shoot back? So you can, with greater impunity, engage in offensive cyber operations. And so ambiguity in the minds of many, well, as a matter of fact, ambiguity does foster operational and strategic level flexibility. And so these states who are engaged in these operations, who like this ambiguity, they have an affirmative policy of trying to create, preserve, and exploit the gray areas of international law, the areas where the law is not clear, to create gray areas, for example, the sovereignty debate. In Tallinn 1, not a single, not once did anyone contest the notion that sovereignty was a rule of international law. Not once. And we scrubbed every document that was written on Tallinn 1. We had a group of grad students, read everything. Not a single time. Those who will remember the Hague process, because some of you were here, in other words, when you came and looked at the drafts of Tallinn 2, there was no objection at all to the notion that sovereignty is a rule of international law that may be violated. On the contrary, there were arguments that not only was it a rule of international law, but it was a rule of international law that even applied to non-state actors, something which most of us did not agree with, but nevertheless, it wasn't, we don't like sovereignty, it's like, we like sovereignty so much we want it to apply to everyone. Okay? So they're creating gray area in an area that was clearly black and white. The same is true with IHL. They're trying to preserve gray areas. So the failure of the GD to agree on countermeasures and due diligence. Okay. Well, these are both areas which I have strong views on both of them, as some of you know. But they are areas that reasonable people differ. And so to the extent that they're an area that a reasonable person would differ, it's a gray area, and states that want to preserve ambiguity so that they may operate in cyberspace are going to embrace the ambiguity over countermeasures. Hence the reason that, for example, the Russians and the Chinese will not accept the notion that there are these rights to respond in cyberspace, in other words, countermeasure. And they will exploit the gray areas, and we've seen this over and over and over again. In the kinetic world, this is, of course, little green men in the Ukraine. But we're seeing the same thing in cyberspace. It's no surprise that the operations against Estonia in 2007 were full of gray areas. Is Russia responsible for the actions of the young hacker groups? They're kind of tied to the Russians, but not really. What was the responsibility of Russia with regard to putting an end to the operations? Did Russia have an obligation to help Estonia to get on and on and on? The DNC hacks. Had the Russians hacked in and changed election results, it would have been crystal clear that this was an act of intervention into the internal affairs of the... But it's not what they did. What did they do? They came in, they got some emails, they exfiltrated emails, they made their emails public by giving them to a third party. Is that intervention? Well, I'm not sure. I worked with someone, Lise Vihul. She's an eminent scholar in this field, an Estonian. She thinks it was an intervention. I think it was, but we're separated by about 1 point. I'm a 49%, or I'm a 51% it's intervention. She's a 49% it's not. It's very gray. It's very gray, and so these states will operate in this area. And that means that cyber war will be asymmetrical, because you have two types of states. You have a state committed to the rule of law. I'd like to say that is the United States. Okay? States that are committed to the rule of law, I'll use the Netherlands, because everyone believes the Dutch are committed to the rule of international law. Netherlands is committed to the rule of law, so when the Netherlands conducts operations, if the law is gray, they're going to err on the side of finding the operation prohibited so that they don't violate international law. And if they're trying to respond to a hostile cyber operation from another country, then they are going to, again, hesitate to respond in accordance with international law if the law is unclear. So you may only take countermeasures in response to an internationally wrongful act if it's not clear that the act directed against the Netherlands is internationally wrongful, unlawful. Then the Netherlands will hesitate to respond to countermeasures in response to that actions. And the opponents know that. And so the opponents will exploit the hesitancy. The net result is asymmetrical warfare in cyberspace. My concern, and I have to tell you, I'm seeing this in my view, my concern is that the good guys, the rule of law states, are also starting to operate in the gray area. That there's pressure in the rule of law states to start saying, wow, they're going to operate in the gray area, so must we. Now, this is deja vu for those of you who follow counterterrorism and so forth. How many times in the aftermath of 9/11 did you hear an argument just like this? And just generally in counterterrorism. My concern is that now we're starting to see good guy states who are committed to advancing the rule of law in cyberspace starting to say, well, maybe those bad guys, the Russians and people like that, folks like that, they're onto something here. Maybe we should do that too. And that's dangerous. Now, I'm just going to finish up with a few areas. I won't go into the law. I'm happy to discuss all of them because I want to leave a little time for questions. Some of the areas where I think there's gray area. The number one is human rights. I'm not even going to talk about that because we almost came to no conclusions on human rights. If you read the manual carefully, it says this type of, generally it says, this type of cyber operation implicates the right to privacy. Well, all that means is we couldn't decide if it violated the right to privacy or not. We're just saying, hey, you're real smart, you're a human rights person, you figure it out. We think, though, you ought to think about privacy. Okay, sovereignty, I've talked about that. I believe that states that are fighting sovereignty will fail. Why? Because sovereignty is a useful normative firewall to hostile actions. Although there are entities within states that want to have a free hand to conduct offensive operations, eventually the state will figure out, no, if we're a rule of law state, we want to be able to pin the rose on the other state. Moreover, we want to have available to us the options that international law provides us in a self-help mode to respond to unlawful operations. But the gray area will continue to be in the future what it is now. When is sovereignty violated? Intervention requires two things. Intervention by one state in the internal affairs of another. It requires an act with respect to the domain reservé. In other words, a realm of activity of a state that's reserved to the state. It's not committed to international law, and it must be coercive. This is a big gray area because in your field, does human rights, the fact that there are human rights norms with regard to what happens in a state's territory means that it falls outside the domain of reservé of the state, because human rights committed to international law, such that other states may in fact act coercively in another state in order to foster human rights. So human rights will loom large in the context, has a gray area in the context of intervention. Attribution, no matter where you go, we did it yesterday, no matter where you go, the first question everyone asks is attribution. Everyone wants to talk about factual attribution. That's fair. What's the legal standard? Not what does a techie think the attribution should be. What's the legal standard for attribution? And moreover, this question, when is it that I can say the actions of a non-state actor are attributable to a state such that you may treat the state as having committed the action? This is a very gray area. And then something for those who were with us yesterday that we talked about ad nauseum, due diligence, the obligation of a state to ensure that its territory is not used to mount harmful cyber operations against another state that have serious adverse consequences. The question is, does this principle even apply in cyberspace? It's a principle that comes primarily from international environmental law. Does it make sense to apply it by analogy to cyberspace? I said serious adverse consequences. Well, what's a serious adverse consequence? You know, if my iPhone doesn't work, I don't care. I've got Post-it notes everywhere, but like my daughter freaks out. Okay, her life ceases to proceed. Is there a duty to prevent? We talked about this. If there's a duty to stop harmful operations from your territory against another state, do you also have a duty to take action to prevent? In the human rights context, if you have such a duty, do you have a duty to monitor what goes on in your cyberspace to ensure it's not harming other states? Whoops, gray area. And then finally and briefly, the jus ad bellum. We talked again yesterday. Noam Lubell, who will be joining us later, gave an interesting presentation on the gray zones in the jus ad bellum with respect to Article 2.4 use of force and Article 51 armed attack. And then for the international humanitarian law lawyers, you know there are lots of issues. A big issue is, can a cyber operation and a cyber operation alone initiate an international armed conflict between states? And can cyber operations by a non-state actor initiate a non-international armed conflict with a state? These are unsettled questions. And then there's the classic question about which volumes have been written. What's an attack? Attack is a legal term of art in humanitarian law. What's an attack in humanitarian law? And so finally, I'm here to take the other side. I think that these ambiguity junkies are throwing the baby out with the bathwater. They have a fair argument, but the long-term consequences of being hesitant about embracing international law are pretty severe. I believe that clarity enhances deterrence. We're all deeply in search of deterrence. Well, it enhances deterrence because it makes the bad actor know that there will be consensus condemnation of their activity for having violated international law. Moreover, deterrence is about understanding the costs of your operation, of your decision to undertake a particular cyber operation. If international law is clear, you know, for example, that you've opened the door to countermeasures. You know, for example, that you've crossed the armed attack threshold and the other state may respond against you with a cyber use of force or even a kinetic use of force. I believe it also lowers the risk of escalation. And we talked about this, you'll recall yesterday, escalation. There's a risk, if we don't know what the rules of the game are, there's a risk that we'll misunderstand what we're seeing here. So state A thinks it's engaged in a lawful action. It conducts the lawful action, what it believes to be a lawful action against state B. State B goes, whoa, what was that? You just violated international law against me, thereby allowing me to take countermeasures. Now state A goes, holy cow, what are those countermeasures? I didn't violate the law. But because you took wrongful countermeasures, I get to take countermeasures against you, ba, 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 ba. This is, of course, for the military historians, this is the lesson of the air war in the Second World War. A spiral of misunderstanding, and it gets worse and worse and worse. And I believe that if we know what the rules of the game are, that lessens the risk of misunderstanding leading to escalatory spiral in cyberspace. And finally, and this is the most important point. Every time I talk to one of the ambiguity junkies, I say, don't you understand the concept of sovereign equality? It's the most fundamental concept of international law. And what it says is what's good for you, it's good for me. So to the extent that you open the door to your conducting cyber operations against other states, which I believe is sometimes necessary, okay? You do the same to other states. If you're going to say there's no sovereignty, when the Russians hack into into U.S. cyber infrastructure, you cannot say they did something unlawful. And I believe over time we're going to wake up and figure out that no, we do want to label such activities unlawful, because most of the time, countries like ours and countries like this country, most of the time we do follow the law. So we're at an asymmetrical disadvantage if we discard international law. And with that, I think I have a few more minutes. I'll take some questions. How long do you want me to, because we started late?
Yeah, we started late, so we can go 15 minutes.
We'll go 15 minutes. I'll take any questions. Yes, ma'am.
Mike, thank you. That was,
The mic.
Oh, Mike?
you have to say that again.
Mike.
Thank you. Mike, thank you. That was a great presentation. Really helped me.
But you have to say that because
thinking
we're
about- No, I'm gonna say-
long-term friends.
I'm going to say why, and then I'm going to ask two questions. It really put the pieces of the puzzle together for me up until sort of yesterday. So that was really great to hear. Thanks. So two things. First of all, if you would agree to go back to that, what you described as the backpedaling moment of the latest
Right.
GGE.
Right?
And I'm interested in pinning down what your thinking is about the normative weight of the fact that the GGE did not make any conclusions. Do you put that in a category of opinion? Yours, as a classical international lawyer, how do you think about that lack of activity? in
So,
terms of the
I
GGE?
mean, I'm hesitant to answer this with guys like Yuval Shani in the room. But I would say that is implicit opinio juris because they were in fact talking about legal norms at the time. And the inclusion of the term self-defense and the inclusion of the term IHL was expressly rejected. And it was expressly rejected on the basis that they did not apply to cyberspace as of yet. So I think Yuval would be better at answering this than me, but I would see this as certainly the statements of the Netherlands and the United States, which supported these two terms, are opinio juris. The 2014 U.S. submission to the GGE qualifies as opinio juris, but I would interpret to some extent the pushback has opinio juris as well.
Okay, great. A question
you
two,
agree?
if I may. It's a short one,
Yeah,
Levi,
okay.
I promise. So I want to push a little bit on the sovereignty fluff fest. That term I
The
just
fluff fest?
made it up under your inspiration. So we kind of skipped over that a little bit. To what extent do you think the bringing a sovereignty into the realm of definitionally a principle rather than a binding norm, to what extent does that reflect? Is that a response to the Chinese and Russian approaches to cyberspace, where sovereignty is very much a part of how they think about their presence in cyberspace?
So the Chinese, as you know, in particular, kind of sort of embrace sovereignty to the point where they believe that they exercise sovereignty even over Chinese data stored abroad. That's really and we recognize that view, by the way, in the Tolan Manual, if you recall, we did do that. I don't think it's a reaction to the Chinese. I think it's a fact. You have to look at where these arguments are coming from. And by the way, I do not want anyone to leave here thinking I think these people are crazies. The attorneys involved are serious attorneys who are principled individuals and are personal friends. So I don't think this view is crazy at all. I simply disagree with it. But in cyber as in life, what you see depends on where you stand. You know, you've heard me say this before. So if I'm an agency and my agency is tasked with the obligation of conducting offensive or active defensive cyber operations against other states, when I look at sovereignty, all I see is a hurdle. All I see is my boss wants to conduct this operation. My boss claims he needs to conduct the operation for national security reasons, and I'm going to go in and tell him no over and over again. And so I think if you look at where the discussion started, it tells you a great deal. In my country, it started with the Department of Defense, which conducts offensive operations. I don't know that the same view would be held at the State Department. And certainly in the Hague process, you know, the Americans were present, and we never heard that. You were part of the Hague process. You came. We never heard that. And so I think, and in the UK, I think the same thing is happening. This argument is coming from folks who fairly are concerned about the fact that they've been tasked to defend this, to engage in operations that advance the national security of the United Kingdom, and they'd want a free hand to do so. But I think that they'll lose. This is a momentary flash in the pan, and these folks wield the cool stuff. You know, man, we can data. I mean, we're all taken by this. But at the end of the day, we're all going to be concerned about our ability to protect our cyberspace, because it's central to the functioning of our societies. And if you take sovereignty away, it's pretty hard to find an internationally wrongful act. Now, the response to this is, and it's a good question, Deb, the response to this is, yeah, but, you know, Mike, if there's an operation conducted against the United States or Israel, and it doesn't violate sovereignty, my response won't violate sovereignty either. In other words, sovereign equality. So we're not taking away our ability to respond. Our ability to respond is intact, because otherwise we would have to characterize the response as a countermeasure, okay, which is harder to do. My answer is that's correct in cyberspace. But as we all know, you certainly know, as we all know, countermeasures do not have to be in kind. They don't have to be at the individual or the entity that attacked you. And they don't have to be in kind in the sense of cyber, cyber, non-cyber, non-cyber. And so, you know, as you were there yesterday, I think you were there, when I said you may have a state that lacks, Estonia. You know, I love Estonia, okay? Estonia does not have a robust offensive cyber capability. But Estonia does have a territorial sea. And the Russians are very interested in passage through the Estonian territorial sea, the Baltic territorial sea. And so the Estonians, in response to a hostile Russian cyber operation, might decide not to shoot back in cyberspace because they lack the capacity, but may well close transit through the innocent passage through the territorial sea to Russian warships. That would hurt Russian commerce. They could hurt the Russians. And so if it's not a violation of sovereignty for the Russians to hack into Estonian cyber infrastructure, then the Estonians can't close the territorial sea, because closing the territorial sea to Russian innocent passage can only be justified as a countermeasure, because they have a right. So, you know, they need to think harder, Again, states make international law, not law professors, but I don't think this has been thought through. This is an argument between people it's an argument between offensive and defensive. I'm a defensive guy. Okay? I played football. I was a linebacker. Okay? I was not a quarterback. All right. Yes, ma'am.
So how do you map the role of the private sector? The question is, so the question is about the role of the private sector. So a lot of the gray areas address issues that are also related to things that are concerning the private sector. And so you talk about countermeasures and the definitions and offense and defense, and these questions are concerning the private sector as well, right? What is whether cyber active defense is defense or offense, right? And the boundaries are blurred. And here, when you talked about clarity at the state level, you talked about it as a measure for enhancing deterrence. But for the private sector, this is a measure of reducing liability and accountability. And so one would expect that insurance company norms, liability, tort liability, you know, would actually develop some of these norms that would actually play back into the state level as well, right? Because once we have a definition and we're setting up the norms, and there are many players rather than states here. So this is a question.
So public international law is generally not about non-state actors, generally. I That's a gross overstatement, but generally not. It's about state-on-state actions. When we did explore the issue of private actors, and in fact, we met with private actors, a couple of us. I went to Cardozo University and met with a lot of senior general counsel and talked about our work and got feedback. There is a problem in this area, and the problem is that the rules of the game are for states. And so let me give you some examples. A non-state actor, and in particular a private entity like Google, does not have the right to take countermeasures. Okay? Does not have the right to take countermeasures. Now that doesn't mean they cannot take action in response to a hostile cyber operation, but to the extent that that operation would be wrongful if conducted by the state, then the state must empower the private actor to do so. So what we've been urging is that there needs to be a robust dialogue between the private actors in cyberspace and the state actors, because the state actors are the ones that hold the authority. Okay? So Google can strike back, but Google needs to ask Washington first, and Donald will tweet his response. There is a big debate over whether private actors are subject to certain of the prohibitions in international law. One is the prohibition on sovereignty. There's at least one state that believes non-state actors may violate sovereignty. I don't agree. There is at least one state that says that non-state actors may violate the prohibition on the use of force found in Article 2.4. I don't agree, but there's that. But by and large, we're talking about apples and double-decker buses when we're talking about the private sector and states. And what this means is that, and there are lots of issues. I'll give you a very interesting one. State A attacks a private actor, Sony or whoever, in State B. Okay? The state lacks the capacity to respond, or the state simply elects not to respond. The private company, therefore, says, what the hey, you know, I'm going to respond. So it responds back into State A, okay, which had launched the hostile cyber operation in the first place. State A now says to State B, yo, what's happening here? There are private actors in your territory conducting harmful activities, harmful cyber activities against us, and you have an obligation of due diligence pursuant to international law. Make them stop defending themselves. Now, we dealt with this scenario, and we dealt with it through application of the principle of estoppel, okay? But it's a valid question. It's a valid question. It's theoretically, I think it goes well beyond theoretical in terms of could this happen. So here's what I think. I don't have any good answers for you because public international law doesn't address them. So I think that, as I said, that it's incumbent upon people like Schmitt and so forth to bring together the two communities and to do more than blah, blah. Now, we've done the blah, blah stuff ad nauseum, okay? What needs to start happening now is states need to start developing understood rules of engagement with respect to these operations and who can shoot back and how much notice you need, under what circumstances are you given authority in advance. They need to think through issues like if a private entity is responding to a hostile cyber operation, is that hostile cyber operation attributable to state as a matter of the law of state responsibility and so forth. But right now, nothing. People often ask, what about Tallinn 3.0? My answer is I ain't going to do it. But if there's a Tallinn 3.0, this is the area where I think some work could really be done, or something like Tallinn 3.0. Yuval.
I'm going to ask a short question, and maybe we'll collect a few, and then
Okay.
we'll wrap up. So my question is on the human rights chapter of Tallinn, and
Horrible.
yeah, and specifically on Rule 36, which deals with the duty to protect the human rights of individuals from abuse. You alluded to that in the slide.
Right.
Now, you don't use the words due diligence in this chapter,
Right.
And I'm wondering whether this is a conscious choice or this is or accidental, because the discussion does allude to standards of appropriateness and reasonableness and feasibility, which would normally be associated with a due diligence obligation, but the actual two words are not mentioned there. So I'm wondering whether this is just a deliberate omission, or whether you can say anything about variations in the application of due diligence in an cross-border operational sense and within the state. But let me now pass it.
Well, I can answer it very quickly. We pass it to whoever. But So this is one of those things that you Israelis are horrible at. It's not the only thing, but this is one of the things. You should never embarrass your guest publicly. And you've just done that. Our friendship is over. It's broken like a twig. So the truth is, and I think this is fair, Deb, correct me if I'm wrong, truth is we just didn't think about it. The way the manual was written, it was written by an expert in the field in the beginning, and then it started this process of chipping away. It would come into Lise and myself, we would redo it, we'd give it to the IGE members, they would comment, blah, 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 and we just never got there. It was not intentional. It was not an intentional decision. It's just due diligence was written by one person who was focusing primarily on jurisprudence and commentary deriving from primarily international environmental law. And we had a well-known human rights attorney doing the other one, and then folks that you know, Marco and stuff, chipped in and so forth. It was not intentional. In Tallinn 3, which I believe you agreed yesterday to direct, Tallinn 3, you can fix this error. Yes, sir.
Mike,
Hey,
thanks
Pat.
for your presentation as always. I was
Morning.
going to ask you about the intersection between IHL and human rights in cyber.
Yeah.
So the
Okay.
old favourites, right? In a non-international armed conflict in State
Yeah.
A,
Mhm.
the organised armed groups are utilising infrastructure in State B.
Right.
And they're using it for military purposes.
So a non-state group in
Non-state group,
State A
oh,
is
yeah,
using
organised armed
infrastructure
group,
in State B
B.
to conduct attacks against State A.
For military purposes, so they're
Okay,
using it
for
for
whatever
all kinds
military
of
purpose.
all
Proper
kinds of military
purposes.
purposes. That's right. What's the right paradigm to apply in State B? Are we applying the law of armed conflict and able to conduct attacks on military objectives on infrastructure in State B, or are we, because it's a non-international armed conflict, are we supposed to apply a human rights paradigm in State B?
It depends on which, it's a very good question, Pat. It depends on which perspective you take with regard to a conflict that's going on now called the geography of war conflict with non-international armed conflict. So I've written a pretty well-known article on the thing. I believe that you define non-international armed conflict by virtue of the parties to the conflict. And so we're looking for a state-state and international, and we're looking for state non-state actor or non-state actor non-state actor in non-international armed conflict. And so for me, the non-international armed conflict is global. It's wherever the actors are. This doesn't mean you can conduct with impunity operations into other countries, because those countries, the third countries, or the second countries in the case of a non-international armed conflict, enjoy rights like sovereignty, for example. So you have to find a way to get into that state. You have to find a legal mechanism to be operating in that state. But once you're in the state and you're conducting the operation, in my view, the paradigm is IHL. However, the ICRC, and I think it's no surprise, I'm a big ICRC fan, okay? The ICRC has taken the view that IHL and a NIAC is limited to the state and to spillover territory. I've asked them the question of, but wait a minute, in cyberspace, spillover territory can be like global. I mean, you know, it strikes me as spillover if I'm using a server in another state. And no, for them, it's a geographical spillover. So if you take the ICRC approach, where you define the geography word geographically, okay, state plus spillover, in this case, human rights would be the prevailing regime. I want to emphasize, because I was one of the first, I should say this in this audience, very few of us are old enough to remember in the days when Darren will remember, he's already a general officer, he'll remember the days when he was a youngster and the old people would come and say, human rights does not apply in armed conflict, IHL is lex specialis, and it completely, I was one of the first to say, I don't believe that's right. I believe you have to look at circumstances. So I want to hasten to add that in the scenario that you suggest, there may be human rights law implications as well, because the operation against the server will have bleed over effect on others. And I mean, so I think it becomes a very complex. But for me, the prevailing, not the exclusive, prevailing would be IHL. For the ICRC, it would be international human rights law. And but I find their argument reasonable. I think this is Yelena Page, author. She's one of my best friends. I find it perfectly reasonable, but not the better of the two positions. Yes, sir. Here.
Thank you for the presentation. Just
Yeah,
another
good to see
principle.
you.
Yeah, nice to see you. Just another question about another international principle: sovereign equality.
The what?
Sovereign
Oh,
equality.
okay.
Even in the line world, it is very disputed how far in practice it applies nowadays, where the different, like the power structure is so different, and all the more in the online world. We will see in the debates how far, like, states are very different in
Right,
their virtual
right.
power. So what does it mean in practice to you?
Yeah.
Yeah, thank
Oh,
you.
it's a wonderful question. So this is what I keep, that's a great question, because this is what I keep telling the ambiguity guys. The world's changed. Ambiguity was good. So I'm a retired military officer, okay? I was targeting officer. So ambiguity is pretty cool when you're the superpower, okay? It would do what I want, you know, it just doesn't matter. But in cyberspace, you may have super empowered minor states. So again, I mean, Estonia is, my secret love is Estonia. Estonia doesn't have a robust cyber capability, but Estonia is full of superstar cyber guys. I mean, when you do Skype, it's Estonian, you know that. When, you know, it's an Estonian company, so it's just, you can't swing a dead cat without hitting a world-class cyber expert in that country. And so Estonia, the concept of equality in practice now has changed dramatically. And so it's no longer, you know, when these people are talking about, I want to retain ambiguity so that I can retain tactical, operational, strategic level flexibility, what I say to them is, don't forget, you're opening the door to states, and there are many more of them now because of this that can take advantage of this against you. So the operation of sovereign equality now, I think, augurs against ambiguity and is in favor of clear rules of the game, because we're no longer in the situation where there's the United States and the Soviet Union and maybe the Chinese kind of, sort of, and that's it. Now, you know, as you said, as was said yesterday as well, I mean, Google's more powerful than states, you know? So, yeah, it's a really, really good point, and it's one of the arguments I make in terms of let's have some law. Okay.
Mike, thank you very much.
Oh, thank you very much. Thanks.
I think we go directly to the first panel. Leila and the wings. Do we have a break? Okay, so we take a 10-minute break.